as panelists with us. The topic on which you'll be enriched today is establishing rule of law. The subheads for discussion are enforceable world law and empowering world judiciary, creating awareness for and protection of fundamental human rights, rights of children, rights of women and gender equality, and legal implications of Arab Spring. This session is being chaired by Honorable Mr. Justice Said Chapter, Vice President, Court of Cassation, Turkey. I hope you all know that official language of Turkey is, any answers? Turkish, right? And the capital of this country is Ankara, right? Similarly, the currency of Turkey is? The currency of Turkey? No, it's not euro, it's Turkish lira. So when we hear them, we also know about something about the country. The other speakers are Honorable Mr. Justice Maximiliano Francisco Benitez. He is from Argentina. Now, what is the capital of Argentina? Will someone volunteer come and answer? Come quickly. Who comes? Nobody knows. No one is confident to give the answer. I heard three persons answering, but they're not coming here. Buenos, is it right? Buenos Aires is the capital of Argentina. And, well, the currency? Is it right? Okay. So we have, and the, capital already we have discussed. It's a country having 23 provinces. Yesterday we were informed about it. And every province have their own executive, their own legislation, and they have their own judiciary. But they have overall it's a federation and overall presidential form of government. We have Honorable Mr. Justice Richard Francisco Checney from Court of Justice, Brazil. Brazil is famous for, what is the other word for football that is generally used? Soccer. In fact, Argentina, Brazil, that side, those South American countries, they are very, very famous for these games. And we are pretty addicted to when the FIFA World Cup comes up. Fine. So, Brazil, the capital is? Fine. The capital is Brasilia. And the official language is? Official language, are they right? It's Portuguese or it's, okay, it's Portuguese. Do you know something about Brazil? That it's the 5th largest country of the world. So we have people coming from such eminent countries addressing all of you. And it's going to be a very, very informative session, very interactive. So it's over to our chairperson, Mr. Justice Said.
Değerli katılımcılar.
Distinguished ladies and gentlemen.
Ben Türkiye Cumhuriyeti Yargıtay.
I am the Vice President, Court of Cassation.
Birinci Başkan Vekili.
And Chief Justice of Supreme Court of Turkey.
40 yıldır hakimim. Hakimlik yapıyorum.
Since 40 years he has been in the service of this judge.
Türkiye Cumhuriyeti
Republic of Turkey
Adalet Akademisi'nde
in the court,
Akademi.
Supreme Court.
13 yıldır ders veriyor.
13 years he has been giving the teachings also for the rights.
Sizin gibi 7500 öğrencim var.
Like
Mezun
you,
olmuş.
he has got 500 students under him.
Hepsi de Türkiye Cumhuriyeti'nde hakim, savcı oldu.
All are in the process of learning judicial studies.
Şimdi
Now,
oturumumuzda konuşmacılar 15'er dakika
all the dignitaries who are sitting along on the stage, 15 minutes will be allotted.
sunumlarını yapacak, konularını anlatacak.
15 minutes will be allotted along with the conclusion.
Sonraki kalan 30 dakikalık
The total will be 1 hour, and the rest half an hour which will be left.
sürede, 30 dakikalık sürede
30 minutes will be,
sizlerin soruları olursa
if there is any questions and answers,
hangi konuşmacıya
any speaker, if you are willing to,
soru sorduğunuzu belirtmek suretiyle
if there is any objective questions will be,
soru sorabilirsiniz.
you can ask any questions.
Konuşmamı fazla uzatmak istemiyorum.
There should be no elongation of speeches.
İlk sözü,
In the first speech,
ilk söz,
so,
anlatımı.
first speech, first speech.
Mr. Justice Benitez'e veriyorum.
Mr. Justice
Benitez.
Justice Benitez from
Very
Argentina.
Süre 15 dakika.
The 15 minutes will be allotted to you.
Buyurun.
Please.
My name is Maximiliano Benitez. I'm from Argentina. No speaking English. Pero quiero decirles que me siento muy complacido de estar con todo este auditorio de niños, que en la Argentina soy defensor de niños, no soy juez, soy defensor de niños. Existe una institución en la Argentina y en algunos países de Latinoamérica que es el defensor de los niños, de las mujeres y de los pobres, y yo soy defensor de esa gente, de los niños, de las mujeres y de los pobres, y es desde ese lugar que he realizado este trabajo.
First of all, I would like to thank you all, and I feel very grateful to be here to see this auditorium full of children. I would like to tell that I'm not a judge. I am a defender, a prosecutor for the rights of children, women and poor people. So this, my topic of the day is going to be related with the same.
Y creo que soy el único defensor de niños de todo este congreso.
And I think that I'm the only the defender of children in in this conference. Let's see. The aim of this work is to show the evolution, the concept of the capacity and the autonomy of male and female children as well as adolescents has had in Argentina positive law. In this sense, in the first place, we shall analyze the first norm of Argentine positive law established by the Civil Code of 1871. Secondly, we shall examine the different normative system in regards to capacity. Thirdly, we shall approach to the consideration of Convention of Children's Right offers in respect of the subject of this work as well as the legislation resulting in our internal law, specifically Law 26061. And at last, we shall comment on the sanctioning of the new Civil and the Commercial Code which came in force on 1st of August 2015. In 1871, Dr. Dalmacio Velez Sarsfield, who carried out the codification in our country, set forth two well-defined categories in the view of capacity for the exercise of rights. The first one refers to inpubescent minors, presenting an absolute capacity of exercise, thus being able to do so through their natural legal representative, their parents. This group comprised those persons being born up to the age of 14. The second one included those in the strip between 14 to 21 years of age who could carry out certain acts especially authorized by law. That system, which may be interpreted as progressive since it established two categories that were prior to the concept of full capacity ruled until the approval of the new civil code which has came into the force during the present year. Changes introduced by immediate laws such as the law 17711 referred only to the age strip, not to the system of the capacity chosen by the first codifier. Therefore, coming of the age was set up to the age of 21 instead of 22. Age limit that suffered a correction in 2009 under the law 26759, lowering such limit to the age 18. In regards to the treatment applied to the capacity of female and male children and adolescents in different normative systems, we can notice that A. Some are enrooted in fixed stipulation according to the certain age. B. There are those that set up flexible norms in which age limits are definitely eliminated. Therefore, capacity is defined as individual evaluation of the child and the adolescent. C. There are models establishing an age limit but allowing for the certain flexibility, that is, they are open to child's providing discriminant and the maturity. D. There are systems that make a difference according to the rights involved, and there being a limiting element for those who could be at risk of being neglected or. As can be noted, the two models reflect an extreme position while the last two are intermediate. Extreme models outstand the providing a stronger legal certainty when they avoid the feared discriminatory decision. On the other hand, intermediate models are more flexible and proper to the idea of progressive autonomy. Notwithstanding, these models have been criticized for lacking a previous process that would determine the degree of maturity, which undoubtedly turns the exercise of the rights more bureaucratic. What's more, the decision is subject to the decision of the judge on duty. We can see that the 1871 Argentine codifier adopted the first system mentioned that refers the age strip as the only parameter defining the capacity of underage, responding to the ruling model of the time, when the child was not considered a subject of law but an object of protection and control in the sight of a state, the family and the society who had an offered guardianship and assistance to him or her. Therefore, this system's essential objective was children's protection. Before the legal model, the Convention of Children's Rights does not define male and female children for his or her needs, for what they still require to become adults, for what impedes their development. It defines them as their attributes for the rights of the state and the family and society. This is the result of considering children as subjects of rights, leaving behind the image of a child who was the object of representation, protection and control of parents and the state. Thus, the real value of the instrument lies on the fact that it opens a new relationship between rights and the children, a relation known as moral and paradigm of internal protection. In contrast to the existing one opened at that moment, acknowledged as the paradigmatic norm of law 10903 of Luis Agoto's law and the state associations of protection of minors and orphans seen as irregular situation. However, the idea brings about a paradox. Even when a child is bearer of rights and his own capacity to exercise them has been acknowledged, the proper legal order does not practice a full autonomy due to the de facto connected to the immaturity and legal consideration. Refer to the traditional legal construction of female and male children as dependent from adults, in particular from parents. Article 5 of the Convention on Children's Rights proposes a way of solving the factic and the normative situation. Stating the exercise of children's rights is progressive by virtue of the evolution of faculties, and their parents and the other responsible people in each case must provide appropriate orientation and the direction so that child be able to exercise rights acknowledged in the convention. The state is to respect parents or any person's responsibility, rights and obligation, assuming the principle of non-arbitrary intervention in family life. Above all, the principle of autonomy reveals that it is the children who must exercise the right according to age and degree of maturity together with the corresponding of adults. Thus, the role of the adults in regards to the life of children will gradually vary accordingly to the evolution of child faculties. What we could ask ourselves at this point is what was the impact of Convention on Children's Rights concept in the Argentine law in regards to the issue being analyzed. And I must say that after the civil code and has been in the force for a long time, International Instrument of the Children's Human Right was ratified in 1990, which in turn brought about the sanctioning of Law 26061 in 2005. The law, also known as Integral Protection of Male and Female Children and Adolescents' Rights, receives and reinforces the principle of progressive capacity and autonomy of male and female children in adolescence. This way, the right of male and female and adolescents is regulated as form of their acknowledgement as subject of rights with dignity and having in mind their age and degree of maturity. First, they must freely participate and express their opinion at every issue of their interest. Second, their opinion must be taken into account. Third, their personal development must be respected. Following this historical evolution, the Civil Commercial Code has been enforced this year, and with it, the incorporation of Convention on the Children's Rights principle into our positive law. Under this outline and in respect of different capacity systems, the Code reflects the adoption of the flexible system which considers not only the age but also the degree of maturity in relation to the act to the minor. On the whole, this regulation set forth the age of 18 as the from which a full capacity is reached for the fulfillment of every act in civil life. Anyhow, minor could carry out valid acts before the age when sufficiently maturity has been proved. For example, Article 26 is said norm establishes as the formal age of 16 as a minor fully capable of disposing of his or her own body. In conclusion, it is necessary to state that it was not until the second half of 20th century the international community awarded an entity never perceived before the acknowledgement of human rights. Consequently, they have sanctioned a series of instruments that are being progressively ratified by the different states. Within this context, and after having acknowledged the citizens' civil, social and cultural right in 1989, children's human rights have also been recognized with the approval of International Convention of Children's Rights, that is, international instrument having most advocates within the community of nations. Within this framework and the new civil and commercial code in force, the Argentine state has completed a long process of incorporation of children's human rights, starting back in 1990 with the ratification of the Convention of Children's Rights, which in turn incorporated this instrument into National Constitution, Article 75, Chapter 22, and in 2005 being followed by the sanctioning of the Law Integral Protection of Male and Female Children's and Adolescents' Rights, Law 26061. For this, we may well state our positive law meets the highest international standard in the matter of children's human rights. Thank you.
Thanks a lot.
Teşekkür ediyoruz.
Thanks a lot, Mr. Justice Benitez.
İkinci sunumumuzu da Sayın Mrs. Gervaseti'ye veriyorum. Buyurun.
In the second, Honorable Mrs. Justice Martha Graciela Gervasuti, Judge, Entre Rios Province, Argentina.
Señor presidente, colegas, niñas, niños y adolescentes, corazón y razón de esta conferencia internacional, me da un inmenso honor estar hoy con ustedes y habiendo transcurrido la mayor parte de mi carrera como defensora, me da un enorme placer que conozcan y se involucren en sus derechos y conozcan fundamentalmente su derecho, se empoderen de ello y de lo que le va a permitir reclamar su ejecución y concreción y no que queden en mero postulado. He hecho un trabajo que lo van a leer porque no hablo inglés. Muchas gracias.
I would like to thank you all for being here. I feel very honored and grateful by seeing all your students here. Being a prosecutor of the children's right, I feel very happy to address such a meeting in which I see a lot of children in front of me. As my presentation is going to be read by my translator as I don't speak English. When I was convened to participate in this congress, I began to consider a lot of ideas about the problem that summons us and the contribution that I give in this context. I decided that it would be more rewarding in the debate to convey to you my experience as a defender of children in a city in the interior of my country, the Republic of Argentina, specifically on how it worked, the operation of the rights of enshrined in the CDN once ratified by the state. On December 4, 1990, how to give priority to the best interest of children and adolescents according to the spirit of convention's rights enshrined in it that were not reflected in the background legislation. First, it is worth reflecting what the degree of the awareness of the society towards the rights of children and adolescents, how to incorporate their right in the judicial and social practice. Through time, the international system, which with its organism generated recommendations later captured in the CIDH and the CDN, and the last one, CDN, children's and the adolescents' adolescents are recognized as subject of rights, holders of the essential rights. The state guarantor of compliance has that obligation to them, as we as state operators are faced with the challenge of human right in action, facing the international standard of the human right operations. Once settled this new scenario, we assume the responsibility and the look for the strategies that enable us to fully achieve our role and bring awareness, not only to the state actors but also to the society, in order to create social awareness on the status to be given to children and to respect their integrity and their rights. Since then, there has been gradual process. Argentina ratified last year in October the third optional protocol of the convention. This protocol enables the mechanism of complaints to the Committee of the Rights of the Children. This convention until 2011 was the only international human rights treaty that did not give any of the victim a mechanism of individual communication to present their cases when they do not have resolved in it internally. Only 15 states ratified, including my country. In this order of ideas, where human rights are not seen as mere postulates and static elements, from the public power and the defense, the training of operator was trained in order to reduce the mechanism and improvisation as a strategy of production of new knowledge, generating collection reflection. The ownership of those rights had to be taken, develop awareness, understand different problems of the children and adolescents in their social environment. It was essential to modify the way in which the problem of children and adolescents were perceived, to modify from judiciary the way of acting in the cases where they were involved. From there, we began to hold hearings held immediately after presentation, looking for the restitution of right. We used different tools, including mediation. All the parts involved were there, the defenders and the interdisciplinary group directed by the judge. The hearing of every child was valued primarily in the assessment of the circumstances of the case, and the child was recognized as a person. What seemed so obvious, but it was not in practice. Work was carried out by accepting the needs and defending the rights of children, knowing that the same are subjects and not objects. In this way, the judgment must be the instrument that allows the satisfaction of his or her interest that cannot be postponed. In accordance with the CDN Article 3, 9, 12, I will refer now to some causes to depict how it was favored the CDN over local legislation. One of them is Ocampo Viela, annulment of adoption, which makes place from demand of the kid. In this case, two brothers, 2 and 4 years respectively at the time of adoption, after the 7 years of the long process to return with the biological mother and regain her surname, claiming their identity, which they had not been able to build with their adoptive family. It was worked with the children. They had their right to be heard, as well as the statement made by them. There were technical evaluation from the behavior of the children. It was clear that they were capable of forming their own judgment and express their opinion freely. Finally, they returned with the biological family backed by their adoptive parents who understood and shared their reason. The children resolved the conflict from the affective and relation aspects, the right of their origin, the shaping their membership, and the clarifying their identity. It was imposed that justice legitimize such situation from the law. So it was decreed to nullify the full adoption, giving priority to the interest of the kids. CDN Article 3 and 12. Another case, Rosen Figueroa, where a girl is authorized to move and settle abroad despite of opposition of their family, taking into account article of CDN 2 and 3. Okay. Another way to foster children's right is under warranty of the amparo. Such action comes from the clear violation of the fundamental guarantees established in the Constitution. As an example, let me tell you that I have solved an amparo presented by Mr. Advocate General on the behalf of a child that was about to receive a heart transplant and whose recovery demanded a suitable environment for building comfort, which his family lacked. At the hearing were doctors who also made intervention, and state representative was also there, who held the necessary means so that the family would have dwelling what the situation required. Regarding education, I can give you an example of trade union dispute that kept children 3 months away from the school. In the representation of Mr. Advocate General, raised an action of amparo, and by the conciliation it allowed to ensure to the children the right of education. There was a disputed case, the Ortega case, in which the family judge dealt a situation of child malnutrition and making the convention to operate and ordered a third party, a supermarket, to provide food in emergency, making responsible to the state the payment of the goods and the appropriate compensate the debt of the tax burden. Apart from the controversy of the process is achieved the realization of essential right with the immediate effect demanded by the situation, giving priority and the interest of this family provided for the convention and other legalizations. Not only the state should ensure the right, but also the third parties, with the possible of doing so jointly and severally with it. While these actions have individual effect, also contribute to diminish rights and allows people to empower themselves into those rights, and those who undermine them could take awareness even the consequences of breaching their obligation. Today we speak about children and adolescents, not of minor synonym of, and we will responses with the reality of each of them, leaving aside the formalisms without real content. Right as mere declaration are not useful to ensure their enjoyment, clearly as human rights are not self-sufficient. In human rights is, in conclusion, there is no linear responses in the reality of the child as an individual in their interest different. We consider it their cultural and the social and family environment and not from the preconception of archetypes of the family beliefs or experience of adults. What makes necessary to judicial operators to be looking for alternatives in each particular case to determine and ensure the best interests of each child. Today there is a new Argentine Civil Code, and it innovates deeply to the order of constitutionalization of private law and establishes a community of principle between the constitution and the public law and private law that directly impact on the right of children and adolescents, leaving behind definitely the old doctrines, merely guardians and the conception of the family. In the specific cases of how we have worked, the concept of child rights means recognizing the children central place of the construction of the subjectivity of ancestor of the personality, the conditions of biological immaturity of the dependence of the terms of care. We have neglected this position that ignores of growing ability of the children to produce creative, participatory own thinking, appearing sometimes its uniqueness through disorder and complaints when it is not suitable to rules arbitrary taken by adults. Is that we need to adopt what we have been developing as to respect autonomy, freedom, promote creativity, all this to ensure effective economic, educational, recreational needs necessary for the process of development toward adulthood. In the term of evolution of human right around the judicial proceedings, a fundamental pillar is education. Thus, I would like to prefer to the way they teach us in law schools. In general, because those who are part of the enforceable part of the rights are lawyers found in them, as this is far from the most of the time with what we should be educating and committing to the right of the most vulnerable and the poor or the weak, as would say Ferracoli. It has always been priority to study the personal and patrimonial marriage system. Thank you. Just a slide line. A few lines. The new Civil and Commercial Code of the Argentina comes to implement a new paradigm which shall be constituted in the compulsory subject of houses to study. Therefore, we shall have a more equal basis between men and women. They are recognized right of assembled, single parent families, gay rights, cohabitation, transsexual, whatever the family model. Yeah. As background law, there is no longer discussion of morality that is intended to be imposed by those who are in charge of education, exercise, and application of law according to the concept of family, vision, and childhood as such. The universal began to articulated. Fine. Thank you.
Children, if a person is reading out something, you have to be very attentive. This particular speech had so many examples, right? You get to know about what's happening in other parts of the world, how the rights are being protected. So be attentive and listen carefully.
Teşekkürler.
Thanks a lot.
Şimdi bu sınıfta bulunan öğrenci arkadaşlarımız
In the classroom for all the students,
ya çok şanslılar
you are very fortunate
veya çok şanssızlar.
or unfortunate,
Çünkü tam bir Birleşmiş Milletler,
because for all the dignitaries,
Türkiye,
Turkey,
Arjantin,
Argentina,
Peru, Brezilya.
Brazil,
Tam bir Birleşmiş Milletler.
we are all together. So you are considered yourself to be very lucky and fortunate.
Şimdi sözü 3. sıradaki Sayın Mr. Çekin'e bırakıyorum.
Third speaker for Honorable Mr. Justice Richard Francisco Cecchini, Judge, Court of Justice, Sao Paulo, Brazil. Please.
Thank you. Mr. Chowdhury, President. Mis colegas magistradas Gervasuti and Jara, Mr. Benítez, hermano argentino, mi colega magistrado argentino, students, my dear friends, how are you? Sorry, but I don't speak English. Okay, thank you. Sorry. I will be very brief. My country, Brazil, decided to address the problem of domestic violence with the help of children, the students. That's because in our country, the most common form of violence against women happens in the own home. Then, the children are usually the unique witness. We create, then, a story in comics or cartoon, I don't know, teaching children to report any violence against their mothers and themselves. Look. This story in comics or cartoon, I don't know, sorry. It was an educational way to teach how to deal with domestic violence, ensuring to an environment free from any form of violence. It's a direct, low-cost, and great child appeal. It's a model that we would like to present to the other participants of this conference, and that can be useful for any country. Thank you. Namaste.
Teşekkürler.
Thanks a lot.
Şimdi sırada son sunumu yapacak olan Sayın
The last, not the least, Honorable
Mrs. Jara.
Mrs. Justice Dr. Olga Dominguez Jara, Family Judge, Superior Court of Lima, Peru. Please, proceed on.
Namaskar, Dr. Gandhi y su distinguida esposa, señores magistrados de distintos países visitantes, estudiantes y profesores del Colegio Montessori School, damas y caballeros de esta maravillosa ciudad de Lucknow. Me siento emocionada en razón que este día es muy especial porque Dios me ha dado la oportunidad de poder participar en esta 16ª Conferencia Internacional de Jueces del Mundo. Mi especialidad es ser juez de familia en la especialidad penal. Juzgo a adolescentes mayores de 14 y menores de 18 años que han cometido delitos o faltas a la ley penal.
Good afternoon.
El tema a tratar es justicia juvenil restaurativa.
Good afternoon, distinguished Mr. Gandhi, Mrs. Gandhi, various distinguished authorities from all over the world, students, teachers, and ladies and gentlemen. I am honored to be here to participate in the 16th Conference of World Judges, and it is a special day for me. I will introduce myself saying that I work in the family court in Lima, Peru, and I usually deal with cases that involve adolescents from between the ages of 14 and 18. And the topic of today's lecture would be Restorative Juvenile Justice in Peru.
El tema a tratar es justicia juvenil restaurativa, de ahí que la nueva corriente que se tiene en la que refiere que el adolescente, la víctima y la comunidad afectados por un delito participan conjuntamente en forma activa en la resolución de conflictos con la ayuda de un facilitador. Así tenemos que en la justicia restaurativa su propósito es que el adolescente internalice su responsabilidad y repare el daño causado. Es por ello que la justicia restaurativa introduce en este marco la reparación y la conciliación como tercera vía, junto a las medidas socioeducativas. Se trata de establecer la paz jurídica reconciliando las partes, víctima, comunidad e infractor, y reparando los daños causados.
The topic today, like I said, is restorative juvenile justice, which is the new procedure where the adolescent, the victim, and the community affected by a crime participate together actively in conflict resolution with the help of a facilitator. So in the restorative justice system, the purpose is to internalize responsibility into the teenager and repair the damages caused. That is why restorative justice was introduced into this framework of reparation and reconciliation as the third way, along with various socio-educational measures. This is to establish legal peace, reconciling the parties made up of the victim, the community, and the offender, and repairing the damages.
Este plan se sustenta en acciones en el marco internacional y nacional en materia de adolescentes, como es la Convención por los Derechos del Niño y el Código de los Niños y Adolescentes de mi país, centrando las acciones del Estado en tres pilares: la prevención, que es la más importante, la administración de justicia y la resocialización, restauración, con el objeto de disminuir el número de adolescentes involucrados en infracciones penales, priorizando el enfoque restaurativo y la mejora de los programas socioeducativos tanto en el medio abierto como cerrado.
This plan is based on plans of actions laid down in the international and national framework on adolescents, known as the Convention on the Rights of the Child and the Code on Children and Adolescents. The state's actions or the government's actions focuses on three pillars. First, and the most important, being prevention of the crime. Second, administration of justice. Third, resocialization or restoration. In order to decrease the number of adolescents involved in criminal activities, prioritizing restorative approach and improving the socio-educational programs in both open and closed environments are important.
Por ello, que el tema a tratar lo he enfocado en la justicia juvenil restaurativa, porque las medidas que se apliquen a un adolescente infractor deben tener como principal objetivo su reintegración a la sociedad. De ahí el énfasis debe ser siempre educativo y resocializador.
Therefore, the topic I have focused on is restorative juvenile justice, because the measures to implement an adolescent offender to improve an adolescent offender must have as its main objective their reintegration into society. Hence, the emphasis should always be education and resocializing of the offender.
Ello no implica desconocer que existen jóvenes que muestran conductas reticentes a los programas de resocialización, y si bien constituyen un grupo menor, requieren de la implementación de un tratamiento específico y acorde con la naturaleza y gravedad de la infracción cometida y sus características personales.
This is not to deny that there are young people who are reluctant to participate in programs of rehabilitation, and although they constitute a small group, it still requires the implementation of a specific treatment which is consistent with the nature and gravity of the crime and the offender's personal characteristics.
En el año 2005, en el Perú se instauró el Proyecto Juvenil de Justicia Restaurativa, desarrollado por la Fundación Tierra de Hombres de Suiza. Este proyecto fue concebido y diseñado a partir de un diagnóstico sobre la administración de justicia para adolescentes. Gracias a una planificación estratégica con participación de representantes del sector del Estado y la sociedad civil involucrados en justicia juvenil, se dio inicio al proyecto y a la ejecución, quien estuvo a cargo de la asociación Encuentros Casa de la Juventud en mi país. Para ello se eligió dos zonas pilotos, una en la ciudad de Lima y otra en la ciudad de Chiclayo, en el Perú. Después de 4 años de haber fortalecido la aplicación del modelo de justicia juvenil restaurativa, este modelo pasa al Estado.
In Peru, in the year 2005, the youth project restorative justice was initiated by the Terre des Hommes Foundation in Switzerland. This project was conceived and designed from the point of view of a diagnosis on the administration of juvenile justice, thanks to a strategic planning involving representatives of the state sector and civil society involved in juvenile justice. The design and execution of the project was begun under the association called Youth House Meetings. For this, two main areas, one was in the city of Lima and another in the city of Chiclayo. For this, two main areas were selected. One was in the city of Lima and the other was in the city of Chiclayo. After 4 years, the application of Por favor.
El 3 de octubre del año 2010 se suscribió el convenio de colaboración institucional entre el Ministerio Público con la Fundación Tierra de Hombres, filial peruana, y la Asociación Encuentros Casa de la Juventud, constituyendo un programa estratégico que tiene como finalidad asegurar la adecuada aplicación de la remisión fiscal a los y las adolescentes en conflicto con la ley penal, con el apoyo de un equipo interdisciplinario y con la participación de instituciones públicas y la sociedad civil, bajo los principios de la responsabilidad, reparación del daño y reinserción social, habiéndose creado 7 distritos fiscales donde se está aplicando la justicia juvenil restaurativa. Con ello se ha logrado garantizar los derechos a 3.465 adolescentes intervenidos en los distritos fiscales, donde se implementa el programa de justicia juvenil restaurativa. Se ha logrado que la mayoría de los adolescentes culminen los programas de orientación con bajos niveles de reincidencia. Del 2.9% de adolescentes atendidos volvieron a cometer una infracción.
After 4 years, the application of restorative juvenile justice model has strengthened, and this model was transferred to the state officially on October 3rd, 2010. The institutional collaboration agreement between the collaboration was an agreement between the public ministry and the Terre des Home Foundation, which was the Peruvian subsidiary, and the association called Encuentro Casa de la Juventud, constituting a strategic program that aims to ensure the proper implementation of fiscal reforms for adolescents in conflict with the law, with the support of an interdisciplinary team and the participation of public institutions and civil society under the principles of responsibility, reparations and rehabilitation. Having established 7 fiscal districts where restorative juvenile justice is being applied, it has managed to secure the rights for 3,465 adolescents.